So I would like now to hand over to another keynote speaker, my friend Mans Jacobsson. I introduced him before as for his former job for more than 20 years, but he's also a law professor and he was a judge. So I think he embodies the spirit of our conference, that is between economy and intellectual skills and cultural skills. He'll speak to us try to answer to the question, to what extent do international treaties result in the uniformity of maritime law? This is a topic that in the first 3 editions of Shipping and the Law we discussed also with another keynote speaker who is Professor Francesco Berlingieri. I hope that next year we could have again Professor Berlingieri with us. He lost recently his wife, so he did not feel to be with us. And so the president of the Comité Maritime International sends his best regards to all of you, and his son Giorgio Berlingieri, the vice president and also the president of the Comité International, but also the president of the Association of Italian Association of Maritime Law. He sends his best wishes, and he sent me a text that I will read during the next sessions. So to conclude the introductory section, I hand over to Mans. To what extent do international treaties result in uniformity of maritime law? I asked Mans to speak with the background of the 7 Works of Mercy by Michelangelo Merisi da Caravaggio. So you will will be hard to concentrate on these words, but you should listen to them because it's Mans brings here always very interesting topics and questions and hopefully answers. Thank you.
Good morning. I had actually thought of speaking from the table there, but being offered the chance of speaking against the background of Caravaggio, who would say no to that? I've never done it before. And then you have something nice to look at and not at me. My contacts with Italian law goes back to the 80s and 90s when I was director of the International Oil Pollution Compensation Funds. It was a very stimulating experience, but of course from an Italian point of view, rather sad, because it was due to 3 major oil pollution incidents that happened in Italy: the Patmos in the Strait of Messina in 1985, and in 1991, the tragic ferry disaster, the AG Abruzzo, and finally a haven incident of Genoa. But I then had the great privilege of working with a number of eminent Italian lawyers, and I came to admire the intellectual way they approach legal issues, and perhaps not so surprising because it's based on the Roman law thinking, which we, even in the remote Northern Europe, where I come from, have been greatly inspired of over the centuries. Turning now to the subject what I've been asked to talk about, that is the extent to which international treaties really contribute to the uniformity of maritime law. We of course know that over the years, a large number of international conventions and other treaty instruments have been developed in the field of maritime law. And this is perhaps not surprising because shipping is a global trade, and uniform international rules are important for all stakeholders in this field. The first conventions were adopted already in 1910. They were about salvage and collision of vessels. In 1924, we got a convention on limitation of liability and the famous Hague Rules on the transport of goods. After the Second World War, there has been a proliferation of international treaties in the shipping field, and in particular due to the efforts of IMO. IMO has here adopted conventions on a multitude of subjects, and Mr. Metropolis had already referred to that. But there have been other actors as well. UNCITRAL gave us the Hamburg Rules and perhaps also the Rotterdam Rules. The ILO, the International Labour Organization, together with IMO, adopted in 2006 the Maritime Labour Convention. And we should not forget the overarching treaty in this field, the United Nations Convention on the Law of the Sea, UNCLOS, which actually contains a number of provisions of public law nature dealing with shipping. The main purpose of treaties is, of course, to create uniformity. In view of the multitude of conventions to which I've referred, the question is then, one could expect that we have arrived at a very high degree of uniformity in the field of shipping. The thing I want to discuss with you is this really so? And if not, what are the factors that are obstacles to the unification of maritime law? Now, firstly, we must realize that a number of treaties that have been developed never enter into force. Or if they do, they are ratified by only a limited number of states. Or that it comes into force but without participation of the major states in the field. It's obvious that treaties of this kind cannot contribute, at least not significantly, to the uniformity of maritime law. And then it's not enough that treaties are adopted and ratified, but they must also be implemented properly in the national law of various states parties. And effective implementation of the treaties may be an obstacle to the correct application and interpretation of the treaties. Now, when you come to implementation, there are, of course, two main methods for implementing international treaties, international law, the monistic system and the dualistic system, and both of them have their advantages and drawbacks. Under the monistic system, a treaty that has been ratified by a government and published in the official gazette becomes directly applicable as domestic law of the country. And this is the case in many countries based on the European continental law traditions such as Italy, France, and Spain. In many of these states, the provisions of the treaty then have a higher constitutional rank and prevail over other domestic law. Problems do arise, however, if during the implementation process the legislator has not looked at the relationship between the conventions and existing domestic law. Because although, as I said, the treaty should take preference, but this is not always in the real world the case, the judges may have a tendency then to apply domestic law with which they are familiar. In the states using the dualistic system, the things are more complicated. In order for a treaty to become part of national law, it has to be implemented through a domestic statute, which then reflects the substantive contents of the convention. And this method is used by many states based on the common law tradition, such as Australia, Canada, India, United Kingdom, but also the Nordic countries, in my view, regrettably. The implementing legislation is then drafted using the technique and the linguistic way that these countries normally use for their domestic law. And that means there is a risk that unintentionally, when they transform the treaty into national law, mistakes are made, which means that the domestic law is not in conformity with the convention. And I must admit that my country, Sweden, is no better in that regard than anybody else. And this, of course, will cause substantive difficulties in interpretation. And in some states, the courts are not very keen on looking back at the convention to get guidance for the interpretation of the national law, and even less inclined to go back to les travaux préparatoires, the preparatory work that led to the adoption of the convention. Now the question is then, how do courts really do when they apply conventions? Do they do it properly? Well, there are, of course, a number of difficulties here. Firstly, and I'm an old judge myself, judges are also human beings. And they are, of course, based on their cultural tradition, on the legal technique, on the interpretation technique prevalent in their country. And it is also so that a judge that is confronted with a difficult shipping case may never in his career have any dealing with treaties before. So he may then pull back and say, well, I'd rather apply the domestic law here because I'm used to that, rather than these strange provisions in international treaties. There is another problem. In many states, like Italy and my own, Sweden, the official language of our country is not an authentic text of the convention. So the courts then will have to work on translations into the national language. And if the translation is bad or inaccurate, that will of course cause major difficulties in the application of the national statute. Another problem is that conventions in shipping have traditionally been drafted, to a large extent at least, in the Anglo-Saxon style. And this may not, even after a good translation, be easily understood by a judge that is trained in the European continental system. In addition, the court may actually disregard that the conventions are actually to be seen in its international context and try to interpret the convention or the implementing legislation as it had been a proper domestic statute. And this may very often get it wrong. And let's be honest about it. The courts may sometimes be influenced by political considerations, and the public anger that very often erupts after a major shipping casualty may also subconsciously have an impact on the judge's way of looking at things. Another problem is that conventions very often leaves important questions open. Why? Well, it could be that the problem has been foreseen, but perhaps more usually it is because it had not been possible at the diplomatic conference to get an agreement how a particular problem should be solved, so the question is just left out, which means that the various states, either through their implementing legislation or the national courts, we have to confront these issues, and it's obvious that you here could get great disparity between the various states' parties. Now, even if I may have been a little critical, I must recognize that all these international treaties have probably resulted in a greater uniformity in the law of shipping than in many other legal fields. But in my view, much remains to be done, and the question is now, how could the situation be improved? Is it more treaties? Some people will say we have to adopt new treaties, we have to amend existing treaties as soon as we find a problem. With all respect, I don't agree with that. The IMO Assembly has repeatedly emphasized that new conventions or amendments to existing conventions should be developed only if there is a clear and well-documented compelling need. In my view, it would have a much greater impact if international treaties that do exist are actually ratified and properly implemented by a sufficiently large number of important states so that they could have the desired effect of harmonizing shipping law. And here the various stakeholders in the private sector could make valuable contributions here by making representations with their respective governments, pressing for them to ratify important conventions. And efforts in this direction have actually been carried out by the Comité Maritime International, the CMI, in cooperation with the International Chamber of Shipping and the International Shipping Federation. But we must remember that law is not and should not be static. Law must develop to take into account changes in society and in economic, social, and political priorities, so as to ensure that the law meets the requirement of society in rapidly changing worlds. And this applies to treaties as well as to domestic statutes. And for this reason, it will be necessary from time to time to amend treaties or adopt new treaties also in the maritime field. But the result may actually be less rather than more uniformity. Why is that so? Well, as states ratify the new and amended treaties, other states may not. And we will then get two treaties covering the same subject matter with different substantive provisions, which of course adds to the confusion. And we only can easily see a very striking example of that, the international carriage of goods, where we have the Hague rules, the Hague-Visby rules, the Hamburg rules, and possibly in the near future, the Rotterdam rules. This difficulty has, to some extent at least, been overcome as regards some conventions adopted under the auspices of IMO by the introduction of a simplified method for amending conventions, known as the tacit acceptance procedure. Under this procedure, amendments are adopted by a qualified majority by the competent IMO committee. And if the adopted amendment is not opposed by a certain number of states within a specified period of time, the amendments come into force for everyone, also for those states that have opposed them. So here you avoid the problem of having parallel texts of conventions have a different substantive content. This procedure has been used, for example, on the technical parts of SOLAS, MARPOL, and various codes, and also for the conventions having limitation amounts in the field of liability and compensation. But so far, one has not gone further to this, and this is partly for constitutional reasons. Many states would probably have difficulty in accepting this procedure used in a wider field. But competent international organizations could contribute to the uniformity of maritime law in other ways than development of new conventions or amended conventions. They could, for example, examine difficult questions of principle, of interpretation, or by addressing issues that have arisen after the adoption of the convention and trying to get recommendations by the highest body, the Assembly, how the provision should be interpreted. And I will give two examples, again taken from IMO, because that's where I'm most knowledgeable. One is the issuing of certificates for insurance for bareboat chartered vessels, which was a tricky issue. And the other is a proposed reservation to the 2002 Athens Convention for the carriage of passengers by sea, relating to the difficulty for ship owners to obtain insurance covering acts of terrorism. Here, recommendations, they are only recommendations, they are not binding, but they could probably have a considerable impact if they are well worked out, and I think they have. The organizations could also develop soft law in the form of guidelines. And again, turning to IMO, it has carried out important work in this field, for example, the adoption of guidelines on place of refuge and on fair treatment of seafarers. Again, they are not binding, but they could have a fairly persuasive effect. I should, of course, also make reference to the European Union here, because the EU has in recent years taken an increased interest in shipping. And international treaties are, as we know, agreements between states. And as the European Union is not a state, it cannot normally ratify international treaties, which causes problems for the European Union member states. And some treaties do contain, however, provisions that allow what is called integration organizations, such as the EU, to become parties. There are in the shipping treaties of this kind, UNCLOS, the Rotterdam rules, and the 2002 protocol to the Athens Convention. And UNCLOS and the Athens Convention protocol have actually been ratified by the European Union. Why is this a problem? Well, experience shows that there may arise conflicts between the binding force of a convention or European Union member states and European Union law, if the European Union itself is not part of the treaty. And as you know, European Union law takes over. So the European Union member states might then be in breach of their convention obligations. If, on the other hand, the EU itself also becomes part of the treaty, the treaty then becomes an integral part of European Union law and takes precedence over other European Union law instruments and also on any domestic statute of a European Union member state. And furthermore, the European Court of Justice will then have competence to rule on the interpretation of the Convention, which could contribute to a higher degree of uniformity within the European Union and its member states. There may also be other ways of promoting uniformity of maritime law. Training, for example, of officials in ministries dealing with implementation of conventions might result in better legislation. And it might also be the civil servants aware of the importance that in the implementing process, they really look into the relationship between the treaty and other domestic law. Judges who are dealing with international aspects could be given training, teaching them how to interpret conventions and generally on international affairs. And training of practicing lawyers wouldn't be bad either, would it? Technical assistance could be given developing countries so as to enable them to build up expertise among judges, ministry officials, other civil servants, practicing lawyers. And here, of course, it would be amiss not to mention the valuable training given by institutions such as the World Maritime University in my own hometown, Malmö, Sweden, and the IMO International Maritime Law Institute, IMLI, in Malta. Supervision by international bodies could also assist in improving the situation. And here, of course, the Imo Audit Scheme, and I know that Mr. Metropoulos had a large impact on creating that. This audit scheme is so far voluntary, but will become mandatory as of the 1st of January next year. And this scheme will include an examination by independent examiners of how the states parties implement certain conventions. SOLAS, MARPOL, International Safe Management Code, and Casualty Investigation Code, to mention a few. So far, the number of treaties subject to this audit is limited, but I think it's fair to expect that this will be expanded later on to cover also other treaties. And it's to be hoped that in the medium and long term, this could have a beneficial effect on the uniformity of application of treaties in the IMO member states. You wouldn't be surprised if I mentioned the International Oil Pollution Compensation Funds that administer the compensation regimes relating to oil pollution from tankers, established by the Fund Convention. And these funds have, through their decisions on the interpretation of the relevant treaties, especially as regards the concept of pollution damage, greatly contributed to the achievement of a fairly high degree of uniform application of these treaties as between the state parties. Finally, a difficulty is here due to the fact that the application and interpretation of maritime law treaties rests with the courts or the public authorities of the various state parties. In the field that I'm most accustomed, that relating to conventional liability and compensation for tank pollution, there are a number of cases where national courts have profoundly misinterpreted the convention or even deliberately, plainly ignored the conventions and applied national law. And the same can be said about many other treaties. Lack of respect for the provisions on shipping matters and UNCLOS could also be mentioned. As I see it, the only way to ensure a high degree of uniformity in the interpretation and application of maritime law conventions would be to confer jurisdiction in, at least as regards matters of principle, on an international court or tribunal. I think it's obvious, however, that there is no significant enthusiasm or political will going down this road, except as has been done on very particular fields, for example, the competence conferred under the UNCLOS on the United Nations Tribunal for the Law of the Sea. So consequently, when it comes to the uniformity of maritime law, we are not, as in most other areas of human life, not living in the perfect world. We have to accept the reality that uniformity in maritime law falls short of what most stakeholders would prefer. And we also have to accept that it's unlikely that there would be any major improvements in the situation in the foreseeable future. Thank you.